Hello, this is David Scher. This is David Scher, listening to alerts on my computer and speaking to you about Physics 572, Introduction to Health Physics. We're in Unit 8, and we're going to begin with that. So first, let me start with an administrative matter. So our schedule. Okay, I'm going to share my screen so you can see where we are. And this is the schedule that we are currently operating under. We're in this week right now, the week of the 6th. I'm going to talk about radiation safety regulations. And we're scheduled for next week will be spring break. We won't have any class or anything going on. And we're scheduled to have an exam after that. And then it's going to be followed by, let's see, 5 weeks of classes. I'm going to suggest that I would rather flip-flop those and have a week off for spring break, then discuss radiation detection and measurements, and then do the exam. Otherwise, it's going to be a very long time and a lot of information for the final. So I think this might balance things out a little bit better. Does anybody have a different opinion about that? The other thing is, I think 2 weeks away might be a bit excessive. So I'm going to post this on Blackboard. Anyone live or anyone who is viewing this after the fact, you've been informed. That's how we're going to proceed. And now we're going to get into the topic of today, which has to do with regulations. So I'm going to move some things around on my screen and then go full screen with my slides, get them ready. I know there's nothing more enjoyable than watching somebody talk to themselves about the things they're doing on their screen, but we will be fine. Okay, so again, let me share my screen now with the slides. And there we go. Today we're going to talk about radiation safety regulations. I don't know whether it's become apparent through the course of the semester yet or not, but the way things are structured for this class is we are talking about information that will be part of the courses you take over time. So you will be taking a whole course, a semester-long course on radiation safety regulations. I'm going to give you a little bit of an overview in today's lecture. That was also true with some of the things we discussed before about dosimetry, and you either have or will take Physics 571, which is Introduction to Radiation Physics. That will be cover a lot of the material we talked about with interaction radiation with matter, all the different interaction types, stopping power, all that will be covered in more depth in that course. So this will be an introduction to radiation control regulations, and we'll begin. So first, I want to say that describe the legal basis for regulations. Can people just create regulations because they think it's a good idea or worthwhile? Well, the answer is no. There has to be a legal basis for regulating something. And in the United States, the government consists of 3 branches. There's a legislative branch that establishes the laws, that's Congress, an executive branch that executes the laws, that's the administrative agencies led by the president, and a judicial branch that makes rulings about the laws in particular cases. They decide whether someone has violated the law, and sometimes laws contradict one another, and so the courts have to decide which rule will take precedence over the other. So in the case of regulations, that's an example of exercise of executive authority. So regulations occur to implement some law. It's very common where a law will say that will establish some policy. For example, the National Environmental Policy Act, NEPA, created a policy that we're going to protect the environment and we're going to protect endangered species. And then they leave it up to an executive agency, in that case, the EPA, to come up with a process for doing that. And the law may outline in broad terms what the process will look like. For example, in that case, that you're going to have environmental impact statements, et cetera, as a means for evaluating it, and sets timelines, et cetera. But the technical decisions, the scientific decisions, or detailed decisions are usually left up to the executive agencies because they're made up of experts. So the FDA, for example, establishes standards for what drugs are acceptable. And that's probably because it's better to have scientists and physicians make that decision than to have legislators decide on their own how that's going to happen. Same thing with banking regulations. So people who are accountants and experts in financial practices make up the detailed regulations that work there, even though the law set the basic directions. Well, in the case of radiation safety, the general policies have been established by law, and then we have administrative agencies that make rules that round out the details, that flesh it out. Okay, so the way this works is the statutes are enacted by Congress, and they establish the broad policy, and these statutes are codified or assembled into a book in a systematic way. That's called the U.S. Code. I think a lot of people have heard on the news about, 18 USC something or other, whatever. So it's just rather than just have random sheets of paper laying around, they organize it in a systematic way so people can discuss the laws in a orderly fashion. Same thing with administrative rules. They're assembled into in an organized way in the Code of Federal Regulations. So the Code of Federal Regulations outlines all of the administrative rules for all topics in the government. There are 50 titles that make up the Code of Federal Regulations. Title 10 deals with energy. So we're going to be dealing with Title 10 of the Code of Federal Regulations for most of what we do. Title 40 deals with environmental protection. So EPA rules, for example, come under 40 CFR. 49 deals with transportation. So rules about transporting radioactive material under 49 CFR, 172, 173. Now there's a third kind of law. So we have statutory law, and I told you about the administrative regulations. Third kind of law is when the courts make decisions, they often have to reconcile conflicts. And so when they make those decisions, they create new law, and that's called case law. And that's not codified into some book. It's just that lawyers have to know and work from a more comprehensive way, or less codified way, what the precedents are. They just simply have to have a knowledge of it. And if a court decision is affirmed by some appellate level decision, then it becomes a precedent and it's binding. The decision that's made by your local judge isn't binding on other judges, but if an appellate court affirms it, then it becomes binding. Okay, so one of the laws that Congress has established for making regulations is the Administrative Procedures Act. This law establishes a framework for rulemaking. So an agency, some executive agency, can't just make up laws any old way they want, willy-nilly. They have to follow certain principles and practices. If they propose a rulemaking or a change to an existing rule, then they have to go through this detailed process. In addition, the law specifies that members of the public may petition for some change or developing a new law or rescinding the law, and the agency can't just ignore it. They have to respond to it in some way. When they propose a law, they have to give the public an opportunity to comment on the law. Typically, I believe it's 90 days. Not every rule is subject to public comment. For example, if they're any rules about how they organize themselves or the processes they follow internally for their daily work, which are also specified in the CFR, those don't have to be subject to public comment. It's rules that regulations that establish requirements for the public need to be subject to public comment. And when they do this, this isn't just a pro forma thing where we gave you 90 days and we didn't read anything you sent us. They have to respond to all the comments. They have to give consideration to all the comments and document how they resolved the concerns of the public. And all this gets published in a book called the Federal Register. The Federal Register is published every day by the government. It informs the public of all the administrative decisions that have been reached. Okay, questions so far? Okay. Now, I have mentioned 10 CFR 20 a couple of times, so I'm going to break down what that means. So when you have a regulatory, some reference to administrative rule, the first number out front, in this case 10, is the title. As I said, there are 50 titles of the Code of Federal Regulations. 49 is for Department of Transportation, I believe. Then CFR says what this is about rules, Title 10 CFR. And then the number after CFR before the dot is called the part number. So 10 CFR 20, Title 10, Code of Federal Regulations, Part 20. That's the biggest group under a particular agency. There can be chapters, so several parts together can be considered a chapter. It's you don't make reference. It's uncommon to have reference to a whole chapter. So a chapter, so all the NRC regulations, for example, are Chapter 1 of Title 10 of the Code of Federal Regulations. So all the rules relating to hazardous material transportation is a particular chapter of the DOT rules. That's not specific enough to be useful in most cases. Okay, but Title 10, the title, the CFR, and the part number is a regulation that's devoted to a particular subject. And we're going to look at some of the NRC regulations today so you can see what I mean. After that comes the section number. So in Title 10, Code of Federal Regulations 20.1003, this is the definitions, the section dealing with definitions in 10 CFR 20. So the section 1003, 20.1003 has all the definitions. That's the example I chose. Sometimes there are groupings of rules that cover a few sections that are related, and those are called subparts. And subparts are referred to by letter. And I'm going to go over the subparts in 10 CFR 20 in a minute here to give you an example. So that's the way these rules are cited. That's the way they're broken down. And we use this every day to discuss different rules, this structure. Any questions so far? Great. Okay, I will mention that there's a law that's very important for health physics, for regulation of radioactive materials, the Atomic Energy Act of 1954. It's been amended a number of times, but it's the basic law that establishes radiation safety in the US. The Atomic Energy Act of 1954 prohibits the use of radioactive materials used in or resulting from the nuclear fuel cycle. Period. Done. No one can use it. However, the law allows the government, at the time, the Atomic Energy Commission, to give people licenses to use radioactive materials. So a license is permission to do something that people are not ordinarily allowed to do without permission. So in the 70s, I think, 74, the Congress decided that having the Atomic Energy Commission responsible for operating nuclear facilities and also regulating nuclear facilities was not a good idea, maybe a conflict of interest. So they created two separate agencies. One is the Nuclear Regulatory Commission to do the regulating part, the oversight part, and what's become the Department of Energy to operate the nuclear facilities. and promote the use of radioactive material. Sometime in this century, the laws were, the Atomic Energy Act was amended again. In the first instance, the only thing that was regulated were reactor-produced isotopes, materials related to nuclear reactors. In the early 2000s, they decided they would also regulate radioactive materials that are produced by accelerators and naturally occurring radioactive materials if it's been technologically enhanced or it's been concentrated. So those are now part of the regulatory regime of the NRC. I mentioned that the biggest part of the regulations have to do with the nuclear fuel cycle. So I want to describe what that is for you. The nuclear fuel cycle is how nuclear power is produced, how the fuel for nuclear power is produced, utilized, and disposed of. So the cycle begins on my little diagram in the bottom left. Uranium that's in the ground is either mined and extracted. It's an older method. And then it's milled, that is, these rocks are ground up and dissolved in certain chemicals in these ponds. And then the uranium or thorium material that is of interest is extracted. That's an older technology. It leaves behind, after this facility operates for a long time, these uranium mills, it leaves behind large piles of tailings or materials that were ground up and left behind, often with radioactive materials, not the uranium or the thorium that they're interested in, but with other radioactive materials that are part of the decay chain in this. And so it's left a large number of facilities in the Mountain West region and throughout the US, not just the Mountain West, but in particular in the Mountain West, of these tailing piles. Nowadays, the way uranium is harvested is in situ. So they use drilling and pump the chemicals into the earth to dissolve uranium and then extract that from the earth rather than mining up the rocks, grinding them out, etc. So that's typically what's done in the uranium recovery process now. Okay, so after the uranium has been removed from the earth in some way, it's converted from whatever form it is in its ore state to uranium oxide called yellowcake. Not surprisingly, it's because it's yellow in color. And so that's the final product of the mining and conversion process. Actually the conversion is not that. That's the end of the mining, milling, extraction process. The conversion process is where they take the yellowcake and turn it into a gas. They combine it with fluorine to make UF6. It's a gas, and it's more mobile as a gas, obviously, than it is a rock. And so when these compounds are mobile, then the very, very small differences between uranium-235 and U-238 can be exploited to separate out the different nuclides. And there are a few technologies they use. Either they use gaseous diffusion, they run them along a long track. The U-238 is slower, so it tends to lag behind. U-235 is faster, and so they can separate it out and enhance it a little bit at a time. Or they use centrifuges, where they pump the gas into a centrifuge, it spins out, and the centrifugal force is greater on one than the other. The mass is different, so it stratifies also top to bottom. And so they have a very, very small enhancement of U-235 each time, but they repeat this process many, many, many times. And so if it's enhancing by 1% each time, after a while, you've got a very high level of enhancement of U-235, or enrichment, as it's called, U-235. So the enriched uranium is then used to fabricate fuel. The depleted uranium, that is uranium that's depleted in 235, so it's enhanced in 238, it's almost entirely U-238, is waste material. It's used, it has other uses, but it's not useful for the fuel cycle. The enriched uranium is fabricated into fuel. Now, natural uranium in the soil is about 0.7% U-235. It is enriched for reactor fuel, I believe 3 to 5%, less than 10%, but 3 to 5% is common. It can be enriched much higher than that for military applications. So this enriched material is then fabricated into fuel pellets, and that the pellets are stacked up into rods. They have cladding put around them, and then they're put into a reactor. In the reactor, they undergo a nuclear chain reaction, produce heat, but also produce radioactive material. And then after a while, the amount of fission products, the other nuclides that get integrated into the waste because of the fission. You have a question, Alex, or you? I saw you raise your hand. Okay. The other isotopes that are left, that are the result of the chain reaction, poison the fuel. Those isotopes will absorb neutrons, so you can't sustain the chain reaction. Almost all of the uranium that's put into the fuel when it starts off is still there when the fuel has been spent or used. It just has other materials in it as well. So the notion of a fuel cycle would be that we take that material, we extract the uranium and put it back in the new fuel, blended with new feed material, new uranium, right? So that's what's done in other parts of the world. We don't do that in the United States. A decision was made in the late 70s when I was in college. Jimmy Carter was the president, and we decided we would not enrich uranium fuel in the US. And the reason is that while these reactions are going on, in addition to fission taking place, Alex, you have a question?
I think I remember you talking about this before, but how much of the fuel actually gets used in its life cycle? Like a few percent?
Right. Very, very little amount.
Okay.
But we don't reprocess because in addition to producing all the fission products, the cesium and xenon and all these other elements, when the uranium breaks up, we also produce plutonium. So the uranium can absorb neutrons and undergo decay and become plutonium. Plutonium is a concern for weapons production. And so that because of the risk of diversion of plutonium from a reprocessing facility, the decision was made, we will not reprocess fuel. So all the uranium fuel that has been used that is for commercial reactors, all the uranium that has been used in commercial reactors in the United States is still sitting in the either at the power plant or at a storage location, because we also don't have a disposal place for it at the present time. So that's the fuel cycle. As I said, in some countries, the cycle is complete because the fuel is reprocessed, uranium is extracted, and sometimes plutonium is also used in the fuel. And then we have a mixed oxide fuel. And I see chat here.
Yeah, I was just gonna ask what you thought about that. Like, do you personally think we should be reprocessing our fuel, or do you think it's better not to?
I think that I can see the reasons for both. I think that the reprocessing fuel would be a good idea if we had a good way to secure it. And I see a question about, do these laws, the concepts apply worldwide? You want to expand on this, Kaya? I'm not sure when you wrote this. I just saw the comment.
Yeah, no. So when we were talking about regulations and how we have like the FDA and these like the CRFs and all that jazz, I assume that other countries do have something similar. And I know that
it's my impression that most democracies, most Western democracies, have similar approaches. I think that different countries have different levels of authoritarian, of central authority, and it depends how strong the personality of the leaders are, and whether the structures can contain the personalities of the leadership in different countries. But generally speaking, modern countries have to depend on technical experts to answer technical questions, right? And nobody can know everything. But I suspect, for example, North Korea may be less recognition that the leader can't know everything. But in the anyway. So, but most countries, yeah, that's the case. So where am I? So have I explained the fuel cycle sufficiently? Is it pretty clear to everybody? Are there questions remaining? We're going to go into this in a lot more detail, as I said, in a later course. But that's where we are today. So the Atomic Energy Act defines several kinds of radioactive material. These terms get used in our profession, so I'm going to go through them pretty quickly. First is one type of radioactive material is referred to as source material. Source material is uranium, thorium that's not enriched. It's depleted uranium from that the enrichment cycle. The material that's not enriched, the depleted uranium, is regarded as source material. And ores containing uranium or thorium with concentrations above 1/20th of 1%, those are all source material. So if you work in radiation safety, you will no doubt hear about source material at some point in your life. All it is the feedstock for the fuel cycle. Another term you're going to hear is special nuclear material. Special nuclear material are fissile materials that are able to undergo sustained chain reactions. It includes plutonium, enriched uranium, enriched in U-233 or U-235. U-233 doesn't exist in nature. It has too short a half-life. It's all decayed away. U-235 is a small fraction, 0.7% of natural uranium, but there is a small amount. So I will mention that uranium-238 has a half-life of 4.5 billion years, about the age of the Earth. So uranium-235 has a half-life that's somewhat less. That's why there's a difference between them and why we have to enrich uranium the way we do. These particular nuclides can sustain fission with zero energy, with neutrons that are not energetic. They don't require. There's no threshold to energy threshold before the fission can take place. So they're useful for weapons. It's useful for power plants, and that's what special nuclear material is. The third category of materials, byproduct materials. You'll hear people talk. We will be talking about byproduct materials when we talk about the rules. The original kind of the definitions are sometimes referred to as 11E1 through 11E4 byproduct materials. That 11E is the section of the Atomic Energy Act where it's defined and where the requirements are established. 11E1 is byproduct materials are things that are made radioactive in a nuclear reactor. So they're byproducts of the chain reaction that takes place. They're either the fission products, uranium splitting up into two radioactive daughters, or they're materials that are made radioactive because they absorb neutrons while they were in a reactor. So that's 11E1 byproduct material. 11E2 byproduct material is the byproducts that are left over from the uranium mining and milling operation. I talked about those tailing piles near Rich's house out there in Utah. Those are 11E2 byproduct materials. 11E3 byproduct materials relate to naturally occurring radioactive materials that are pulled up from some other operation. It's often the case that when they pump gas or oil out of the ground, it brings with it radium, and those concentrations of radium are called technically enhanced NORM. NORM stands for naturally occurring radioactive material, and that's that waste that's produced from this non-nuclear process, just mining for different elements, is now regulated by the Nuclear Regulatory Commission. In addition, when these rules were changed, they also added accelerator-produced isotopes in the definition of byproduct materials. So all of the materials that Sonia's accelerators produce at Curium are governed by the NRC. An 11E4 byproduct material is anything else that the Nuclear Regulatory Commission, EPA, Homeland Security, or other agencies decide are similar hazards of radioactive material to the other material. Okay, questions? Okay, so you'll hear about source material, byproduct material, special nuclear material as you go through your career. Even if you don't work around power plants, it's still the terms that are in use. So the NRC governs most work with radioactive materials in the civilian world outside of the government. And they've established rules in 10 CFR. And the two of them have general applicability that you will work with all the time. 10 CFR Part 19 deals with notices, training, and reports to workers. 10 CFR 20 establishes the basic standards for radiation protection, what the minimum level of obligation that's generally applicable to all cases of using radioactive materials. Okay, so those are the two that we're going to discuss today in detail. There are a lot of other rules in the NRC regulations, and I'm going to mention them briefly here. So I told you before that the Atomic Energy Act says nobody can own radioactive material, period, done. We're over with. Oh, but we'll give you a special exception. If you get a license, if you have a good enough reason, we'll give you a license, you can use radioactive materials. The rest of the rules that are mentioned here are about licensing radioactive materials. So there are separate rules for each kind of use of radioactive material where you might get a license. Those are in 30 for byproduct materials, that's 30 through 39. 10 CFR 30 is general rules about licensing for everybody. Part 35, for example, is about medical licenses. Part 37 is about security for byproduct material for licensees. All those parts in the 30s are licensing for byproduct material type licenses. Part 40 is for source material licenses, and there's only one of them, and that's part 40. There's not 41, 42, 43. So there's just one regulation dealing with source material licensing. Parts 50 through 55 deal with licensing for nuclear reactors. If we go back and look at the fuel cycle, we've talked about part 40 is this part down here where we're dealing with source material. Now we're up into the 50s where we're talking about operation of the nuclear power plant. 60 through 63 is the disposal part, high level waste, low level waste, etc. There are other parts that deal with licensing for the gaseous diffusion plants, etc. They're in the 70s. This shouldn't say part 2 for special materials, it should say part 70. 70 deals with special nuclear materials. That's the way the regulations are structured. I will fix that typo before I post these. So let's talk a little bit about the rules that are generally applicable. Now, the regulations that are in part 50, etc., they're often used for by the engineers. The nuclear engineers may have more to do with that than the health physicists. John has a question or comment.
Yeah, I was just gonna ask if 50 to 55 for nuclear reactors, does that include research reactors as well? Or
Yes,
just energy
yes.
producing?
Some
Okay.
of them are, some parts deal with power reactors, some deal with research reactors. It's completely different sets of requirements for well, not completely different. There's some similarity, but the requirements are not the same for research and test reactors than they are for commercial utilization reactors, production reactors. Okay, great. So let's go on into part 19. These are the rules that health physicists often deal with on a daily basis. Part 19 has mostly to do with your interaction with workers and workers' rights in radiation safety. The workers have a right to a lot of information. It must be made available to all the workers, either posted somewhere, or you need to indicate the location where it can be obtained. One is that all workers have a right to see the license and know the license conditions. I think that a big part of the reason for this is that so that workers can know if the company's skirting the rules. They want to know they want workers to know the rules so that they know they're operating safely, and to recognize when rules might not be followed. Workers have a right to see the operating procedures that have been approved. Again, to know what they should be doing and whether things are operating on the above board. Workers have a right to. Do you have another question, Alex? Or
Have you ever seen that be used? Workers, asking to see the license. Like, I'm just wondering how that would work in practice, because
right.
some parts of the license are supposed to be
Confidential.
restricted.
Right. Well, I ran into a little bit of problem with this as an RSO a while ago. So I thought that a very clever way to make this, so you're supposed to post the license. That's the basic rule. It says post the
Really?
license. So and if you can't post it because it's too bulky, you can tell them where to see it. I put a link on our website. Here's our license to come see a copy of it. I got a call from my regulator is, oh, we don't want you to do that anymore because they're concerned. So what happened maybe 10 or 15 years ago, somebody got a copy of a radioactive materials license and went to a company called Troxler. Troxler makes nuclear gauges that you use for measuring soil density. And they ordered, I think it was a reporter, ordered 1,000 Troxler gauges. And the idea was they could then use this material to create a nefarious, So they had a bogus license that they downloaded somewhere off the web or got from somebody, and used this license to tell the company they were authorized to receive this materials and placed an order for it. And then they wrote a big article about how nuclear, how everything's not that secure because you can skirt the system by doing this. And so they asked me to take it down, and we had to come up with a different way. So we just simply say, you can come to our office to see it. The only time anybody has ever asked me to see the license was in a situation where graduate students were trying to organize. And so there were, I think that safety was one of the rallying points for, oh, we're all unsafe, that's why we need a union. And so there were they expressed concern about safety and wanted to know about these things. There are certain things, as you said, particularly related to security, that can't be disseminated, but you can give out the information, redact information that's otherwise secure. But a lot of the stuff isn't secure, right? A lot of the stuff in a license is very generic. Which physicians in a hospital, which doctors are authorized to administer radioactive materials, who the authorized medical physicists are, et cetera. All that kind of material should be available to them, so that they can see if this person really is an approved user or not.
And if they
but in
can't
practice,
get it,
no, I don't see it happening a lot. Go ahead.
and if they can't get it, their recourse is then to contact their local NRC office.
Right. Well,
and
or
escalate.
whoever the regulatory agency is. So I was going to tell you,
Or the state, yeah,
if it's an agreement state. So that's the next item on our list, which you're just talking about. So you're required to post in all areas where workers would have. So you've all seen at your workplaces posters with all kinds of information, right? Workers' right to know, and Pregnancy Discrimination Act, and all kinds of things. Well, one of the things that's supposed to go on that poster is the NRC Form 3 or the agreement state equivalent. And among the things that tells you is what the NRC is and what the obligations of the employer are in terms of safety, and how to contact the NRC if you have concerns. So workers can go to the NRC and if they're denied access to the information they requested, it's a violation of the rules, and or the whatever regulatory agency would then enforce the rule. And Kaya has a question or comment.
Sorry, yeah.
Oh, don't be.
So I assume that the DOE might be an exception, like federal facilities might be like have some exceptions there.
Well, the DOE, it's different because you don't have licenses for the DOE.
Yeah.
So I'm sure that the DOE has its own. I've never worked for the DOE. I'm aware of we're going to talk about their rules in the second hour, but
Okay.
I'm sure there are similar protections, because they don't want, the DOE doesn't want rogue operators either, right? Now there's going to be a lot of information in the DOE that's going to be security controlled information, locations of things, etc. But the procedures that are used, you know, what your exposure standards are, etc. Those all, what kind of respiratory protection you should use. Those are all generic and not security related information. So I'm pretty sure the DOE would make that information available to its workers.
Yeah,
But yeah, there's a lot of information. Sonia, you're lit up.
I don't, in my head, I feel like the Navy had a similar document to the Form 3, but at least on the regulation side, the main regulation book is no foreign, as is the main addendum books. So that's all accessible to
Right.
to most general workers, at least the people that require it, and we're required to have copies of those at like control points and
Right.
stuff.
In the government, DOE
Yeah.
and the military, it's not as facility specific. The
Right.
rules are generic. They're applied across the board, right, Sonia?
The main rules are, however, each site does have their own, how they're functioning.
The
Yeah,
application of it, yeah.
exactly. And the DOE and the Department of Navy are kind of tied together. So their rule books are quite similar, with specific variations as necessary.
Okay, so we have to draw a distinction between security information that wouldn't be accessible, and workers need to be told what they need to do to be safe. They have a right and obligation to be trained and to know what the working procedures are. And that's the kind of information that everybody needs to be provided. Yeah, you're in an NRC state, right, Sonia?
We're in the funky Missouri, but yeah, we're basically NRC for our main work.
Yeah. And Alex, are you?
Yeah.
What do you?
We're smack dab in the middle of Missouri, so yeah,
Oh.
we're very
you're
NRC.
Columbia?
Yeah.
Kind of west, but yeah. Yeah. Okay. And Kaya, you work for the government, right? DOE.
Yes, I work for the DOE.
Yeah.
Mhm.
And anyway, I have been in agreement states and in NRC states, and I was in the Army, so I worked in this. But yes, I don't perceive much of a difference between them in terms of how they regulate. Okay, another requirement in 10 CFR 19 is annual training. There needs to be initial training and annual refresher training for all workers who frequent radioactive material use areas. So that includes the maintenance person who may not work with radioactive materials but has to go in the lab. They need some level of training, and the training needs to be commensurate with the hazards involved that are entailed with their work. They may not need to know how to use radioactive materials, but they need to be trained in the warning signs, what is radioactive, what's not radioactive, and how they can protect themselves. Even though it's much the person who delivers packages in your building, if they deliver them inside radiation use areas, they need training. The other thing in 10 CFR 19 is that workers must be provided with a report of their exposure annually. so they know what they have received in the previous year. Okay.
Which have been
Next.
difficult
Go
to
ahead.
meet with Miriam having all the delays lately,
Yeah.
that's been difficult to meet the
Yep.
standard time requirement, but the NRC has been very understanding.
Yeah, they know you can't do what you can't do. Yeah. So you guys use Miriam. I've heard that Landauer has similar problems.
Yeah, we've heard that too, but our bosses decided we're switching Landauer. So as of next month, we're using Landauer.
20 or so years ago, I worked at the University of Illinois. Landauer is located in Illinois. They had such poor we had such a poor experience with customer service. We went to Miriam, which was at the time was before it was Global Dosimetry, whatever the name was back then. Anyway, so I think it's just a cyclical kind of problem.
Yeah, it's kind of like switching cable companies in some ways. This is not our first time we've switched, and it probably won't be the last.
Now there is a new company out there. I mean,
There is?
Landauer and Miriam are the big behemoths, but there's something, a Radiation Detection Corporation, I think.
I think it's the decision is they're the only two that are big enough for our company.
Probably so. I'm sure they would love that. You get a lot of attention from this new company, but yeah, you want to have somebody who's been around a while and has the infrastructure in place. And that's nationwide or worldwide for you guys, or that's not just your one facility, right?
We have a couple facilities in the US. I
Right.
assume just actually we operate, they were using Landauer, so that's part we've actually
Oh, so it was by location.
It was, yeah, it's by location, but that's part we're trying to, I think, kind of consolidate that because that's a more recent acquisition.
As I recall, do you not have a facility at Murr, or is that somebody else?
No,
That's somebody else.
Pardon me?
that's somebody else. We
Okay.
do some clinical there or supplies.
You buy stuff from them, yeah.
Maybe there's so many things we do.
Okay. Yeah, there's another facility, a competitor that's in like Beloit, Wisconsin, or something like that. I think they were the ones who had the facility at Murr, now that I think about it. Okay, next set of rules that are generally applicable is 10 CFR Part 20. And here's where I have it broken down by the subparts. And unfortunately, I'm going to have to go through all of these, and we're getting close to 7, so I might I don't want to, whoever's watching this after the fact to have to sit through hours and hours of this stuff. So I'll try to hit this quickly. So, subpart A, general provisions like definitions and applicability and purpose and things like that. Subpart B is a requirement to have a radiation protection program, and we'll talk about that in a minute. Subpart C are all the dose limits that apply for workers, and subpart D are for members of the public. We've talked about those briefly in the past. 5 rem per year effective dose equivalent, 50 rem, etc. I'm going to show it to you again. Subpart E, and members of the public, it's half a rem per year, 100 millirem per year, up to half a rem under certain circumstances, or a tenth of a rem. Normal exposure for members of the public is 100 millirem per year. Under certain circumstances, it can be increased to 500. Subpart E is for termination of a license. So you're granted a license, but you can't just wait when it expires, just walk away and leave a bunch of contamination. So in order to terminate a license and be resolved responsibility, you have to meet certain conditions, and that's what the subpart E is about. Subpart F is about surveys and monitoring requirements. Surveys are when you take radiation detection instruments and look for either radiation areas, measure the radiation levels, or look for contamination with a Geiger counter. We're going to talk about instruments next time, and I think that's when we can talk about surveys as well, because different instruments do different things. But surveys and monitoring is like for effluents and that sort of thing. Subpart G is for controlling areas where there are high levels of radiation levels. There's a thing, definite designation called a restricted area when exposures are above a certain level. There's a high radiation area, and there's an extremely high radiation area, grave danger, when they're very high. So those are all part of part 20. Respiratory protection, we're going to talk about that in a minute as part of this thing. So part I is about storage and control. They don't want you to lose radiation control. They take a dim view of that. And so the regulations in subpart I deal with how you control radiation materials and store it. Subpart J are precautionary procedures, and those are largely posting and labeling requirements. So you're giving people warning that where the radiation material is, so that janitor who gets the training gets trained about these signs and labels. Posting is for the door, for the room. Labels are for the objects, for the individual vial or container. Subpart K deals with waste disposal, lots of requirements there. We've had a lot of problems in the history of the US with waste disposal sites. There are requirements associated. Subpart L has to do with records. All those things you did, you have to document and maintain those records for the NRC to inspect. Subpart N is for reports. If something bad happens, you need to report it to the NRC, and that's what those regulations are related to. Subpart N basically says the NRC can exempt somebody from any of these requirements that they have for a good reason in a license, and the other part is they can add additional requirements that aren't in the regulations for good reason. That's what subpart N has. Subpart O, you want to stay away from. That's enforcement. That's if you do something wrong, bad things can happen to you. And if you try to deceive them in the process of something going wrong, they can ruin your day even worse. Okay, so within those rules, I want to briefly touch on subpart B, radiation protection programs. So you have to have a program in place that ensures compliance with all the Part 20 requirements. Typically, a radiation protection program will include audits, surveys, work procedures that employees are required to use for certain tasks, engineering controls. This work must be done in a fume hood. This work must be done with whatever engineering controls are available. And then the radiation protection program usually includes record-keeping requirements, because if it's not documented, you didn't do it, as far as regulators are concerned. The goal of the radiation protection program is to ensure that doses are as low as reasonably achievable. This acronym ALARA is something that comes out about a lot in our profession. You should be aware of the word ALARA and what it means. It means that you reduce doses, not just to the level of the requirements, but as low as you can without breaking the bank. If you have air effluents from your facility, then the exposures to the nearest, the maximum exposed person must not exceed 100 millirems in a year. That's an EPA requirement that the NRC has agreed to take over for the EPA. It's part of the National Emissions Standards for Hazardous Air Pollutants. At the DOE facilities, the EPA enforces NESHAPs. At NRC facilities, the NRC does. It's a requirement in 10 CFR 20 subpart B. Okay. Subpart C has to do with the dose limits. We've talked about these before. I'll just briefly remind you that the limit for the effective dose equivalent is 5 rem in a year. This includes both the external deep dose, DDE, and internal committed doses. We spent a lot of time talking about committed doses, committed dose equivalents. So the total effective dose equivalent is you add up the external exposure, where all the body parts are equally exposed, plus the individual components from internal exposure. When we talked about internal dosimetry, we did this, right? Am I remembering it wrong? I think we did a homework problem where we had some internal exposures plus an external exposure, and what is the total dose. The limit for skin, extremities, and individual organs is 50 rem in a year. The dose limit for lens of the eye is 15 rem per year. Okay. This is all stuff we've dealt with before, so I'll hit that quickly. Now, another thing I haven't discussed in detail, but I mentioned, is planned special exposures. So we have these annual limits, and they're much lower than what came before this. So when I first got in the field, the dose standards were 3 rem per quarter. There was no annual limit. You were limited to 5 times your age over 18. That's how many REM you could have. 5 times n minus 18, n is the age in years. But you can do it at 3 REM per quarter. And so we cut back to no one can exceed 5 REM in a year. It's a big cutback. And that causes a problem for some facilities. So they have what they call the planned special exposures. This is intended for high exposure jobs that occur infrequently. And the idea here is that an individual can receive the annual dose plus 1 more year's worth of dose, all within 1 year. If they do it, if it's not as an accident, it's not something that it does it after the fact. If they prospectively make the decision that they need to do this, and it's a planned special exposure, you can get an extra year's worth of dose for all those different standards. You get 1 more in any given year. And over the course of a lifetime, you can have no more than 5 times the annual limit. So it's a separate checkbook. It's a separate account of dose apart from the annual normal exposures. Okay. Yeah, my last bullet point is you cannot have an accident or a mistake and then say, oh, that's a planned exposure. No, it wasn't planned. It has to be pre-planned, has to be documented ahead of time. The worker needs to get notification ahead of time. They need to be told what their planned special exposure was after the fact, etc. So it can't be subterfuge. Yes, John.
Have you ever seen this?
Nope.
Like the plant? Okay.
I've never worked in facilities that have that kind of exposure. I think this is unique power plant operations or maybe national lab operations where they have one person who's highly skilled at a particular thing, something comes up, some unusual maintenance requirement that only one person can do, and so they allow for it. I don't think it's a common occurrence. That's my impression, and I've never had to do it ever. Okay, a couple things more for 10 CFR subpart C, the standards. Minors, sometimes we have employees who are under 18 years of age. Their limit for exposure is 10% of the occupational limit. It's across the board, whether that's the lens of the eye, whether that's organs, extremities, the effective dose equivalent, internal doses, everything. It's 10% of the adult limit for minors. The next thing that we need to mention is pregnancy. The first point to be made there is that the pregnancy standard only applies if the employee voluntarily declares their pregnancy. No matter how well-intentioned we are, we cannot require women who become pregnant to change their work patterns. We can't decide for them what's important for them. This is the result of a Supreme Court case called the Johnson Controls case. They took a worker out of her responsibilities against her will. She sued them. It was a violation of the Pregnancy Discrimination Act. She won. Women make this decision for themselves as to whether it's more important for their family to reduce workplace exposures, or whether it's more important to continue their careers. If there's a declared pregnancy, the dose of the fetus must be maintained at less than half a REM, 500 millirem, for the entire gestational period. The exposures must be roughly uniform. You can't give all the 500 millirem in one dose and then nothing the rest. It needs to be roughly uniform throughout the period. It consists of the external exposure to the mother, plus any internal exposure because of any dose because of internal exposure that would accumulate in the fetus or from the mother exposing the fetus. We went through internal dosimetry before. It's a complicated process, but that's a requirement. Because we're basing this on declared pregnancies, what if a woman declares her pregnancy after she's already exceeded the 500 millirem? Well, the employer is not in violation under those conditions, but the employer is not allowed to deliver any more dose of the fetus more than 50 millirem throughout the rest of the pregnancy, if the declaration takes place and the exposure is either exceeds the standard or is within 50 millirem of the standard. Okay. So that's the next set of regulations. Okay. Subpart D, doses to the members of the public. The dose, effective dose equivalent to members, any individual member of the public is 100 millirem per year. This is just from licensed activities. It doesn't count. Yes, Alex.
So is that how does that work with the Johnson control thing where you have you know, a worker who has already received dosage during their pregnancy that you know know about because they just
Right.
now declared it.
Right.
And so you say you can't
If-
go over go ahead.
Are they already over the limit or below the limit?
Well, let's say at some point they go over the limit, and so now you're saying you can't do this type of work
Right.
because
Well,
you
they
declared
can
it.
undeclare their pregnancy if they wish. What they're doing when they
Yeah.
declare their pregnancy
Okay.
is they're saying, I voluntarily want to accept lower dose standards. The rules allow a woman to undeclare pregnancy. It's her choice what standards will apply.
Okay.
Okay, this is a right of the worker. It's not a right of the boss of the company.
Okay. Cool.
Okay.
Yeah.
There you go. I see the old guys are nodding. The young people are all gassed. Okay. Let's see. This excludes natural background. The average natural background in the U.S. is about 300 millirem. The dose to the public from all sources, medical, natural background, etc., 620 millirem a year. Include that. This is comparable, somewhat less than what people normally receive from natural background. It's only from licensed activities. It does not include exposures that people receive from medical exposure procedures themselves, or radiation they might receive from a coworker who received has some radioactivity in them from a medical procedure. We talked about that a little bit last time. That's excluded from the calculation of dose to the public. Another requirement that applies to members of the public is the dose rate in unrestricted areas where members of the public might be present. Workers who are not radiation worker or members of the public is 2 millirem an hour. These are separate standards. 500, you have to have less than 100 millirem per year, and the dose rate itself must be less than 2 millirem in any hour. It's not an instantaneous rate, 2 millirem per hour. It's 2 millirem in any hour. Both standards must be satisfied. Now, there are some exceptions where members of the public can receive up to 500 millirem, the old standard. One is if a patient is confined in the hospital, receives radioactive material, and they can have guests if the physician decides that it's in the patient's best interest to have that visit, and then the visitor can receive up to 500 millirem. Okay. The other case is it's a catch-all. If a licensee applies for and the NRC approves exposure of 500 millirem, if it's in the best interest of the all things being considered, then they can approve up to 500 millirem to members of the public. Okay. Subpart H is respiratory protection. According to this rule, the preferred method for managing respiratory protection is by engineering controls. So ventilation is better than wearing PPE, respirators, that sort of thing. Engineering controls are more reliable and more effective. They don't depend on people. The secondary approach is by access control, time limits, and wearing respirators. There are a couple of different types of NIOSH. NIOSH is National Institute of Occupational Safety and Health. It's at CDC in Atlanta. There are a couple of NIOSH approved types of NIOSH approved respirators. One is air purifying respirators. They basically have filters. They're used for particulates. Typically, they're negative pressure respirators. You know, the Darth Vader kind of mask. They can be powered air purifying respirators where there's a motor that forces the air in. They're under positive pressure. The second class is atmosphere supplying respirators. So they're either airline or SCBA respirators, self-contained breathing apparatus. that where air is supplied from not from the contaminated environment to provide for breathing. Each type has a different assigned protection factor. Air purifying respirators are not good for gases. They're good for particulates. They filter out particulates, but a pure gas won't, it's not going to get caught up in that filter material. So for example, tritium, water vapor, not going to be caught up. It's going to pass through. Or radioactive oxygen, for example. Obviously, the oxygen you're breathing gets through, so radioactive oxygen will get through. So those are here are some of the types of respirators and the associated assigned protective factor. So a half-face respirator, I should have had pictures of it. You know, something you wear around your face. It has even N95s that we've all worn through COVID are filtering respirators. They don't have a very high protective factor, but they are. So so negative pressure is when you have to you breathe and you have to suck the air through the filter. Powered air purifying respirators are they have pumps that force the air out under positive pressure. And you can here's the air supplying respirators, either full face or half face respirators. You can see what the protective factors are. That is the ratio of the ratio of how much concentration you would have without a respirator compared to with your respirator. So a half piece negative pressure respirator would reduce the concentration of material by 10 to 1. A full face negative pressure respirator, 100 to 1, et cetera, et cetera. Okay. A loose fitting face piece respirator, like we've been wearing the last couple of years, might be 25 to 1. Although these require seals, and those things aren't typically fit. Anyway, you can see some of the protective factors. I want to show you how that's used. When work is performed using a respirator, the intake and committed dose from that exposure is reduced by whatever that APF is. So I'm doing an example here. Suppose you're working in an area that has airborne cobalt-60, class W. The concentration in the area is 7 times 10 to the minus 6 microcuries per ml. And in the year, they worked in that area for 400 hours. Okay. The DAC, I looked it up, is 7 times 10 to the minus 8 microcuries per ml, and that's a stochastic dose. So it's based on a 5 rem effective dose equivalent. So we normally, if there were no respirator, we would say the exposure is the concentration divided by the DAC times 400. So I picked these numbers for a reason. 7E minus 6 over 7E minus 8 is 100, right? So the concentration is 100 times what the DAC is. They're working for 40 hours. That gives us 40,000 DAC hours, right? 100 times 40. Yeah. 100 times 400. Okay. So the dose equivalent without a respirator would be 40,000 DAC hours times 5 rem for each 2,000 DAC hours. That would be 100 rem effective dose equivalent to that person. The big dose, far above the 5 rem limit. But if they wear a full face negative pressure respirator, the APF for full face negative pressure respirator is 100. So we reduce that by a factor of 100. It's 1 rem. If they wear a powered air purifying respirator, the APF is 1,000. Full face PAPRs, then their effective dose equivalent would be 100 millirem. So it reduces the exposure quite a lot. And we use this in calculating what the annual doses would be. Okay, and in addition, I'm going to take a break here, and we're going to come back and finish this in the second hour. That way I won't have too long a recording for those watching. So I'm going to say goodbye, and we're going to come back and we will start on the next video in just a moment. Okay. Thanks, everybody.